Meanwhile, on the phone, pleasure to welcome to the program senior contributor to The Appeal, Jay Willis. Jay, welcome to the program.
Awesome. Thanks so much for having me.
So, all right, let's this ruling on Monday regarding the Title VII of the Civil Rights Act of 1964 was a bit of a surprise. Neil Gorsuch wrote the opinion. It was a 6-3 decision. It basically says that for the first time, that the Civil Rights Act of 1964 protects people's right to not be discriminated or fired in an employee-employer relationship based upon being gay or transgender. Tell us about how Gorsuch got to this opinion.
Yeah, it's a deeply weird opinion because how do I want to put this? It is, as you note, like absolutely not the result that people anticipated. I certainly thought this was going to go the other way, that it would be a fairly straightforward 5-4 opinion with this conservative court ruling sort of against this, what is a remarkable expansion of LGBTQ rights. But Justice Gorsuch treats it as a very simple issue, and he offers several versions of the same hypothetical. He says, if you were to fire a man for dating a man, but you wouldn't fire a similarly situated woman for dating a man, that's discrimination based on sex. He says it's inextricably bound up in sex. And he summarizes his argument nicely when he says, these cases involve no more than the straightforward application of legal terms with plain and settled meaning. He treats it as a very textualist argument. And the dissents, and they are robust dissents. This decision is almost 170 pages long. 140 of those are dissents from Justice Alito and Justice Kavanaugh. They go into a lot of detail to argue that the legislators who drafted this, they would not have thought that the term sex encompassed sexual orientation. They talk a lot about legislative history, legislative intent, things that purportedly textualist judges usually don't like to turn to when they're interpreting statutes. But
now let me ask you this.
By contrast,
let me ask you this. Well, we may be getting ahead of ourselves a little bit here. So let me just put a flag there so that people remember what you've just said, that textualists don't look to legislative intent. And you know, I'm skeptical, and we will get to this point about just the whole concept of being a textualist and all this, original intent and all of these sort of theories that have been propagated by conservative jurists, because ultimately they seem to find their way generally to where they want to get to. So let's just put a pin in the dissents and just talk about for 1 second, like what the implications of this are in terms of, and I don't think most people knew this, but in more than half the states as of 5 days ago, if you were gay and your employer decided to fire you, they could just fire you because you were gay.
Yep.
You wrote about you wrote about doing intake as a, I guess maybe a paralegal or working in a law firm. Tell that story, because I saw that on your Twitter feed, and I think people will find that interesting.
Yeah, of course. So, as you note, about half of the states don't have their own civil rights laws that protect LGBTQ people from discrimination. So what this results is, until yesterday, is this really messy patchwork of legal protections, where if you're fired because you're trans or you're gay, whether you have legal recourse depends on not on what actually happened to you, but where you happen to live and work. So the way this plays out in practice, I used to work at an employment discrimination firm doing case intake. This was before I went to law school. So my job was hearing people tell me, a stranger, about basically the worst things that ever happened to them, right? And what this means is that as they're telling me their story, they tell me where they work. And in my head, I can already think, oh, you live in a state that doesn't protect you. And before they can even tell me everything, I know in my head that I'm going to have to call them in a couple of days and say, I'm really sorry, we can't represent you in this matter. Best of luck. It's a deeply unfair status quo. It's very arbitrary in the way it's applied, and I'm really glad to see the court close this loophole with this case.
Okay, and so what happens? So in the context of employment discrimination, you can no longer fire someone because they're gay or because they're trans, and so. But what happens? I mean, we have this language. We have the same language in Section 8, right? With housing discrimination. Is housing discrimination now also off the table, or do we have to wait for a specific challenge to someone being denied, an apartment or denied housing because they're gay or trans?
Yeah, we've got to wait for a challenge to come, but you're right. The result certainly seems inevitable or to flow naturally from this. Justice Alito's dissent lists more than 100 statutes that prohibit discrimination based on sex. And his point is that all of those, under the Supreme Court's logic, could now prohibit discrimination based on sexual orientation and trans status. Of course, he's saying that as if it is a bad thing. But yes, this could have sweeping implications for other civil rights statutes that weren't specifically part of the court's opinion yesterday.
Now, let me ask you this. Let's say just hypothetically, I bring a case, of housing discrimination or other discrimination under one of those statutes that Alito cites. When I write the brief and submit it to the court, can I cite even Judge Alito, who didn't agree with this decision, concedes that in this instance, it would apply under this statute?
For all intents and purposes, yeah. So the opinion in Title VII in this Bostock case was a statutory case, not a constitutional case. But the constitutional implications of this are, as we've said, pretty apparent. So yeah, if I were writing a brief in this case, I would point out that this result suggests that the Supreme Court is going to apply this sort of heightened intermediate scrutiny to laws that allow for discrimination based on sexual orientation. You will certainly see this come up in a lot of briefs in other civil rights statutes in the years to come.
Okay, so I want to talk about the relevance of Gorsuch writing this, the majority opinion, both in the context of the implications for textualism as it's applied to other cases in the future, but also in terms of, I think there's about 6 other major decisions that are happening this week that are going to be amongst the most controversial. Trump financial records, the DACA decision, a Louisiana trap law, which would inhibit a woman's right to choose, a case on faithless electors, one involving religious exemption to discrimination cases, and one about the constitutionality of having a Consumer Financial Protection Bureau that does not derive its funding from Congress each year. So give me a sense, like, how much of this is John Roberts going like, okay, this is the way that we're going to release this. We're going to set the table saying that we are not partisan and that we're not coming to conclusions, and we're going to give them this one. And Gorsuch will be even like create his bona fides by writing the opinion, and then the next couple are really going to be ones that it's going to soften the criticism that we're partisan. Like how much does that happen, do you think?
That's a great question. I don't really know how much the order of the release of opinions factors into the justice's decision-making process. But you're right that there's no reason necessarily to look to this opinion as sort of a predictor of how these other controversial cases will come down. This may be sort of the sort of thing that we look back on in a couple of days or a couple of weeks, and we say, "Boy, remember when the Supreme Court did that good thing? Those were the good old days."
Right. All right. Well, let's talk about the dissent and this piece that Joe Patrice wrote that you had linked to on your Twitter feed the other day, because I see something like this, and my first instinct is like, oh boy, this is they're setting something else up here. And you were starting to talk about the dissent that Alito wrote and said that it was. Is it your assessment that it's weird that Alito is talking about legislative intent because he's a textualist, or is it just there? Are we watching a dance between Gorsuch and Alito where they're setting up a sort of almost a black box that is going to allow them to come to certain conclusions in the future?
Yeah, it really is sort of a mask off moment for originalism, which, you alluded to this earlier, and I share your perspective that originalism and textualism, these aren't, superior necessarily tools for interpreting law and interpreting the Constitution. They're tools for conservative Republican judges to arrive at their preferred policy outcomes, which again is why it's so weird for Justice Gorsuch to be issuing this very narrow opinion that sort of claims the mantle of textualism, but leads to this opposite outcome. It's sort of interesting, like Alito isn't wrong that the legislators who drafted this in the 1960s probably weren't thinking about sexual orientation as being part of sex. But Justice Gorsuch retort is that, we just go off the text here, and the text is really clear. There's this idea that the court isn't supposed to look for elephants in mouse holes, that it doesn't elicit sweeping policy changes based on, vagaries or stretches of definitions or things like that. And Gorsuch addresses that in his majority opinion. He says, this elephant was never hidden in a mouse hole. It has been standing before us all along. But what he sort of omits is that the end of that sentence, which is, and also we just saw this elephant for the first time after 50 years, where for the first time, more than 50 years, we're saying that for the first time, yes, sex includes sexual orientation. And it's something that he sort of just glides over. And I think that's the reason Justice Alito is pretty mad about it.
And so, but is Alito in some way also sort of like edifying this concept of the word sex? Yes. I'm almost like confused by it. Like he's not looking at the intent of the word. He's just simply saying that and he's really talking about the gender, right? I mean, sex as gender. If a man dates a man, the fact that the but for is that he's not a woman in terms of why he was fired, and therefore it is about sex. How does that work with transgender?
I think it's a version of the same syllogism, right? That if you are treating a trans woman differently than you would a woman who is presenting as her biological gender, that is discrimination based on sex. I think the simplicity of it is something that Alito can't really wrap his head around, doesn't have a great retort for, which is why he goes into, this long dissent with this long parade of horribles about what he sees as the result of this. It's a straight Fox News culture wars list, right? He talks about, locker rooms and discrimination in sports and, gendered sports, bathrooms, that sort of thing. But he's throwing everything at the wall and seeing what sticks.
All right. So let's talk about this concern about what it means for something like the Chevron doctrine. I think, hopefully, we certainly have talked about the Chevron doctrine quite a bit over the past well, I guess 3 or 4 years in the context of there seems to be a move to return to the Lochner era and to basically, well, why don't you start by telling us what the Chevron doctrine is and why something like Gorsuch's opinion here implicates the Chevron doctrine?
Yeah, so the Chevron doctrine basically says that when an administrative agency issues an interpretation of a vague federal law, the judges defer to the experts, as long as it's reasonable and as long as Congress in the law hadn't said anything that sort of directly contravenes the administrative agency. So what you could see in this case is, Justice Gorsuch is very careful about, he says this is just based on the text, this is a narrow ruling, this is a narrow opinion. And I think you could see that come up in future Chevron cases about administrative decisions. And administrative agencies, they have tremendous power to interpret federal law, environmental statutes, for example, the Clean Air, the Clean Water Act. And you can see this sort of language and this sort of approach coming back in a conservative opinion that says, well, the statute, the Clean Water Act, it doesn't contemplate these sweeping federal regulations. They're too far beyond the bounds of the text. And so we have decided that they are not reasonable.
Okay, so I want to get a little more concrete so that people can really understand this dynamic here. So what happens is with like an EPA, Congress in whatever it is in 2012, let's say just 2008, is just not aware of every single chemical that could be dumped into a waterway. It's not aware of every possible waterway that could in some way, implicate the quality of water in sort of major waterways. And so they give a broad, basically a broad agenda to the EPA. Make sure the water's clean and not, unhealthy. And as science progresses, there becomes awareness that, hey, like this chemical is bad for human beings. And instead of Congress rewriting the laws to include a specific chemical, courts have found that the EPA has the right to say this chemical is unhealthy and it should be outlawed. But according to Gorsuch, because the law does not say blank chemical, therefore, as a textualist, then you cannot presume that the law includes that chemical, and therefore it is incumbent upon Congress to write a specific law, if that's what they want to do, and use the word, blank chemical. I should have probably come up with a fake name of a chemical, but that's basic. That's basically it, right?
Right. Like the process of passing legislation would obviously be really unwieldy, probably impossible in today's environment, if Congress had to list out every single hazardous chemical that is covered under an environmental statute. So it says, it'll issue a law that says, as you say, keep the waters clean, don't dump bad stuff in it. And then the EPA, which is a little bit more flexible, gets to determine what bad stuff is. And you can sort of look at the Bostock opinion as like an edge case. In this case, Justice Gorsuch feels that, the text is clear enough that he doesn't have to sort of strike it down. But in a similar case that comes before him, he could say, look, this, in an environmental case that you mentioned, this EPA interpretation of what hazardous chemicals mean is just too broad. It's beyond the scope of the statute. And so Exxon, you can dump whatever you want into the ocean.
And he's got to make that argument about this not being a elephant in a mouse hole, but rather an elephant that's been in front of us all the time. It's been like very, very obvious, even though no court had found it obvious for, since 1964. He's got to make that argument because he's really arguing that Gorsuch is a textualist there. And so rather than saying that, like, I'm divining now this dynamic, he's got to say it's been obvious that it's there the whole time, and I'm just a guy who approaches things that are obvious.
Right. Chevron deference has been around for a long time. It's a really important concept in the law because it's what allows the government to respond flexibly to problems that come up after Congress passes laws that the legislators couldn't have envisioned at the time. So rolling back Chevron deference is going to be would be a seismic event for the law. And so, yeah, Justice Gorsuch could here be setting up an opinion in which he one day says, look, like, I'm sorry, this seems like such a big deal, but we never should have gotten to this point in the first place.
And I mean, so do you think there are chances that Gorsuch and others are going to be referring to this case as a means in which to essentially dismantle large parts of our regulatory scheme going forward, because our regulatory scheme is based upon this dynamic of Congress looking to these agencies and saying, you're the scientists, you're the experts. Here's our general goal that we want to hit. You guys figure out the way to get there.
Yeah, and I think you can see an analog to this in Chief Justice Roberts' opinion in the 2012 decision that surprisingly upheld the Affordable Care Act. But what he did in that opinion is he upheld it on the basis that requiring people to buy health insurance is within Congress's taxing power. But he also went out of his way to say, look, this is not a legitimate exercise of Congress's commerce power, which is the power on basically which all meaningful, relevant congressional statutes rely. And you're likely to see that opinion come up, if Congress were in the future to say pass a Green New Deal or Medicare for all, you're likely to relying on the Commerce Clause. That opinion could come back, and Chief Justice Roberts could say, we said in 2012, we sort of limited the scope of the Commerce Clause. And I think you could see the same dynamic here,
where the sort of, I guess, the backswing is becomes actually the everything becomes inverted. All the things that they were attempting to promote what appears to be a positive, and I want to make it clear, obviously this is a hugely positive ruling, but the mechanism which they used, they're basically building a machine to attack a lot of other things that those in the center and the left appreciate, I think, of our government.
Yeah, the application in this case is, discrimination is bad. I feel like that is beyond stating the obvious. And the application in this case, the result in this case, is absolutely good. What you could see in the future, though, is the same, the principles that the court used to arrive at this decision being applied in other contexts to have very bad results.
Jay Willis, a senior contributor to The Appeal, thanks so much for coming on and talking to us about this. Really appreciate it.
Of course. Thanks so much for having me.